And today, friends, we'll be discussing to you with the Karnataka Land Revenue Act 1964. In fact, when we speak upon what this act or when we know upon what this act, try to understand what the act is, the very basic thing that we should understand is why is this revenue act brought in? What all the objectives with which the revenue act was being brought? And who are all the officers who are carrying out the administration of these revenue issues are concerned? These are the requirement that what we have to understand in respect of this enactment is concerned. And in fact, if you go with the act itself, my friends, as this is the state enactment, we understand this. This act is applicable to the entire state of Karnataka, and this enactment was brought on the first day of April 1964. It got into its force. The act came into its force. Now, why was the act brought in? What was the idea behind of bringing this act? Friends, we all know this, that, or if you take the history of the development that has been taken place, or the history that has how it has given a way for us to understand what this revenue is. That is in our olden days or our past history, if you look upon with, especially during the period of kings and kingdoms which was there, through which we see the kind of legal system was being brought in. Friends, even those days we see the land revenue was the major source of income for every king or kingdoms. That was the main source through which they used to get a money. They used to collect a money. They used to take the money for that of the maintenance of any king or kingdom basically, or for any state for that concern. And it was also the priority of every kingdom was that they were required to collect the land revenue as far as possible, and they were also they were mainly dependent on this levy and recovery of this land revenue or the revenue. And if you look at with one eminent kingdom, that is Vijaypur kingdom, that is King Todaramalla, who was the first person to introduce the Rohitwari system in our country. He in fact brought out the Rohitwari system and said that the land revenue has to be paid in this regard. And it was so efficiently worked out. This system was so efficiently worked out with, and the same was also adopted by the then Chhatrapati Shivaji, which he brought it in the form of Hindavi Swaraj. And he said that this system, that is adopting this Rohitwari system, it became more popular in the entire part of the country. And probably I can say you this, because of its popularity, even the Britishers, when they came down and when they started ruling India, they were forced to follow this kind of system which was prevalent throughout the country. And that's how we see in the old Bombay provisions, they adopted the same kind of collection of revenue. But in a present scenario, if we see, there is quite changes that has been taken place. A small changes that has been taken place. Of course, today also to some extent we follow the Rohitwari system of collection of land revenue. But still, we see that some changes has been brought into, which says that is even in preparing the records or maintaining of the records, land records especially, we have just come up with a scientific form of having looking into this Rohitwari system, and that's what now it is being followed with. And when you look at with the land revenue administration, my friends, the entire administration of land revenue issues are concerned. He is on the issues like, that is the main concern of this is that is to assess the land, to collect the revenue, to collect the local cess, that is on behalf of the local bodies, even the collection of court fees, recovery of loan, recovery of the land revenue, all this falls under the ambit of the land revenue administrators. Though for us this might be concerned only with that of the land issues are concerned, but the very authority has extended its scope to several areas, and they do all these things right from the collection of land revenue. They get into the assessment of land revenue. They look into the cess what shall be made. They would also help out to that of, they would help out the local bodies in collection of this. Where the recovery of amount comes in, those recovery of amounts are collected in the form of land revenue. All these works are being done by the administrators of land revenue. And we also see, as a part of this work, there is a required preparation and maintenance of land record too. They also exercise the statutory powers which are endowed to them under the Land Revenue Act. So in this form, my friends, they perform various functions. So if you just look at with the Department of Land Administrators, we see that there are 4 categories of department that has been classified under this land revenue issues are concerned. One department is exclusively for the recovery of revenue. The another department is for the measurement of land and surveys department, measurement of land or survey department we call. The another department under this is that the registration of land and its alienation, and the 4th department is the treasury. That is, in every taluka level, we see a department which amounts to be, that is, this treasury, in each taluka it is established, which goes into the collection of the amount from that of the revenue officers. So this is how we see that the entire administration of the land revenue is concerned. However, we say under the section 1, the Act came into force in the year 1964 on 1st April. And today we have a land revenue act. But after this, my friends, when it comes to the second section, I will not be exactly going with the number of section, but at the beginning I'm just mentioning you with this. See, when it comes to section 2 of the act, section 2 of the act goes with the various definition clauses. It gives out the meaning or the definition to several such areas like what is building site, what is boundary mark, what is survey, what is chavdi, what is survey, who is a survey officer, so on and so forth. It goes on giving. But very, very briefly, let me put you across with some of those definitions which is important from the point of your examination, which is just important, of which I would like to say is the class of lands. But before I get into this class of land, very briefly let me speak to you with various definitions. Let me not be again specifying to with what the sections is. Of course, section 2, class 2, 2, class 3, 2, class 5, 2, class 8 goes on like this. Now, what is building in the terms or under the act is concerned? See, when I say the building, or the definition says that it means any plot of the land which includes a open ground and the courtyard. That is, anything which is adjacent to that of the building or erected to that of the building can also be considered to be as a building. That's what the definition says. Likewise, when we go with the boundary marks, it says that any erection, whether on the earth or as a stone or by use of any materials, that is, which also includes any edges, edges or ridge or stripe which is being erected there. That is, which any such mark determines the boundary of the division of land, determines the boundary as to the division of land is concerned, then such is said to be called as boundary mark. So we go on with the definition. Several definitions are there. Like the important what I want to discuss at this very short span of my time is this, my friends. What are the classes of land we come across with? Section 2, class 8 deals with this. Friends, as a whole, when we look out with the classes of land or classification of land, if you look in, friends, when we went in discussing with the introduction class as to the classification of land, the classification of land under the land acquisition or as a complete land loss are concerned, if you look, the classification can be on various types. That is classification on the holding, classification on the sailing, classification on the basis of the irrigation, so on and so forth we come across with. And if the same, if you are looking in the terms of Land Reforms Act, under Land Reforms Act, the classification can be in the form of the table A land, a class A land, class B, class C and class D land. But when it comes to the land revenue, friends, the classification of land or classes of land can be categorized into three areas. One is the dry land, wetland and garden land or plantation land. I repeat, dry land, wetland, garden land or plantation land. In this way we can go with the classification. Of course, if you can also divide this as a fourth one, you can even separate garden land and plantation land as different. If that is the day, so you can say it as fourth classification basically we can make upon with. And what this section 2 class 8 subclass A speaks is that what is this dry land? See, as when we go with this classification of dry land under this enactment has repealed under section 202, which we see, which came into force on or before the commencement of this act, which says that a dry land are those lands which are classified to be as a dry land under this enactment. 1. It says that any land which has been classified to be as a dry land, which includes chalk land or dry land, that is a land where it is not depending on that of the water, where no water resources is being met. So all this are being brought under the shade, under the class of this. But it only we can at this point of this junction we can only say is that dry land has that is been classified or as specified as dry land under the act. The second classification it says is that which includes, which may probably I can say the other enactment does not call for this, which under the Land Revenue Act it says this, that is, if wherein a wet crops cannot be grown except otherwise from the source of the water provided by the state. That is, which I can say in this way, or elaborating this, I can say you in this way, where if the state government or under the schemes of state government, if any such land is being provided with a water from the state, and through that water if a cultivation is being made in that dry land and making that as a wetland or wet crop is grown, then that cannot be considered to be as wetland. So it also says this, that it says where the wet crops cannot be grown except where irrigated by the water source of the state government, then such land should also be considered to be as a dry land. So this is how the definition goes with. The second thing comes is, what is this wetland? See, the land on which the wet crops can be grown by the use of rainwater or water obtained from any other source of water that of the state government. That is, where if it is a wetland itself and if you happen to grow the crops by way of rain or by way of the sources of the government, then we can say that yes, it can be considered as wetland. The third category comes is the garden land. Friends, when I say garden land, it is simply understood like this. Garden land are where the garden crops are being grown other than the plantation crops. I repeat, other than the plantation crops, where the garden crops are being grown, like something like flowers or any small fruits or vegetables as such. When you grow upon with this, then those land are said to be called as a garden land. And again, this garden land can be classified into two. One is dry garden land, wet garden land. The same principle is applied here. That is, where if the land were to be a dry land in which the garden plantation has been gardening crops has been grown there, and where the source of water is not provided to the land for which the land is being cultivated, or if that were to be a designated or it was being set as dry land, but through that of the water sources that has been provided by the government, if you are yielding the crop in that land, then those lands can be considered to be as garden dry land. Wetland, the same thing, that is where the land is said to be as a wetland, where gardening crops are being grown and where the crops can be grown either with the help of rainwater or from any other source of the water that is being provided by the state government, then those lands can be considered to be as a wet garden land. So this is how we can categorize. And of course, if you are categorizing the fourth one, that is the plantation land. Plantation land are those lands on which the plantation crops are being grown, something like cardamom, coffee, pepper, rubber, sugarcane, which can be grown on this. They are said to be called as plantation crops. So if these, except of these lands, or except of these plantation, all other lands on which it is not used for the irrigation but for the purpose of cultivation, if it is being made for the purpose of growing certain fruits or growing certain flowers or other vegetables as such, we come across which those lands can be considered to be as a garden land. So in this way, my friends, the classification we can see under section 2 class 8. They may ask you a question saying this, what is the classification, what is land revenue, and what are the classification that can be made with respect to the land under Karnataka Land Revenue Act. They may ask you a question. So in this form, we can make, when you are to answer this question, you can even make your reference to the Karnataka Land Reforms Act, even with reference to the general observation as to the classification of the land, and straight away get into this of having specifically elaborately writing as how the classification is considered in case of the land revenue. So this is how we can look upon with the classification. So also we have various definitions like who is an occupant, that is any person who is in possession of the property is said to be called as an occupant, but this does not include a person who is a tenant, but a person who happens to hold a superior owning over the land, superior holding over the land, or a superior landlord can also be considered to be as an occupant of the land. Or person who is in occupancy, if you say, who is an occupation, if you say the person who is in possession of the land, or when it comes to the occupancy of the land, the portion of the land which is to be held is called to be as an occupancy. There is also a rental value for this, and for the rental value means the consideration that is required to be paid, that is money paid and or promised to pay either in the form of sharing of the crops or the value of the crops periodically to the government, then that would be considered to be as rental value. That is, when the property has been leased for the period of 1 year, the most advantageous use which we can see in this, especially in case of land revenue, that is when the property is being leased, that is whatever that you are liable to pay either in the form of money or in the form of sharing crops can be the value, or we can call it as rental value. And if you say what is the revenue year, if you take with the revenue here always starts with 1st July of every month and ends with June of every calendar year. So in this is how we see, and standard rate is also there for assessing the land revenue. Standard rate is that when the land revenue is not fixed, is not specified, then the standard rate comes in. And the standard rate is that it depends upon the particular class of land that which the group you are holding with. But however the class of land it could be, that is 4% of the average yielding crops of that of the land is taken as a class of value, or we can say that it is a standard rate of value. That is, whatever that you grow out of that property, the value that what you get in out of that class of property shall be considered to be as a standard rate of revenue which can be payable on it. Likewise, we have several definitions, my friends. Who is a superior holder, who is a tenant, what is survey number, what is survey mark, all these are there, and how terms of settlement goes with all these things are there under the definition class, my friends. But what is for me more concerned here from the point of your examination I am to go with, my friends, the question is quite oftenly asked in the examination is, discuss the constitution and powers of the revenue officers under the Karnataka Land Revenue Act 1964. This could be asked for short notes, or this could be asked for main question, or any part of the survey officers. That is, any one of the survey officers can also be asked for your short notes. Any one of this can be also taken for that. And when that is there, suppose say if they ask you a survey mark, then you should go along with the definition and explain what is survey mark, how it has been categorized with, how it is looked with. These things you have to explain with. Now, let me speak to you with, as I just gave you the question, that is the constitution and powers of the revenue officer under Karnataka Land Revenue Act 1964. Section 3 have just made a point of this here. Section 3, 4, 5, 6, it's the state government, 7 divisional commissioner, 8 deputy commissioner, 9 special deputy commissioner, 10 assistant commissioner, 13 and 14 Tahsildar and special Tahsildar, then 15 revenue inspector, 16 and 7 village accountant, 18 survey officer, and 19 other officers are concerned. These are the sections which speaks with. Let me go very briefly what the powers that they are exercising were. They may ask you the question on any of this part. I can say at least one expected question can be definitely asked from this point of discussion. Now, we all know this. And of course, I can say this, my friends. These are the hierarchy of the officers, revenue officers. This is the hierarchy. See, the first and foremost toughest position or the toughest officer or the authority in respect of the land revenue or in the revenue administration is concerned is the state government. As I will say, or as we understood that it is a state enactment, we all came to know this. So, that is at the beginning of our discussion also with us, my friends. The state government is the chief controlling authority in all matters connected with the land or land revenue or land administration is concerned. So the state government has a part of imposing, exercising all those rules, regulations in respect of the collection of the land, as I then said to you. That is, in respect of all those collections of the land, everything, they has a power to go upon with. That is, for recovery of land, they can impose any rules, they can lay down certain rules, they can make a regulations in respect of all these things. That is, for recovery of revenue or for measuring out the land, they can appoint such other officers. All these are officers. All these officers have been appointed by the state government. So, they have a power of appointment of officers. Kelbodu. They may ask you a question saying that what are the powers of the state in respect of, or explain the powers of the state in respect of the revenue administration is concerned or revenue issues are concerned. Any of these questions can be made. They have a power in respect of recovery of the land revenue. I'm just repeating this. They have a powers in respect of measuring out the land or making a survey. They can appoint a survey department to this. Officers can be appointed in this regard. The registration of land revenue and land alienation can be made. Treasury can also be maintained in respect of the consideration, that is what is being got by the state in the form of land revenue. So all these things are there, we come across with. And when it comes to the powers that what all that is being exercised, I just made a mentioning that right from the appointment, right from the superintendents of all these authorities, right from appointing, looking after, recording, maintenance of records, all this is the part of the state government. That's what section 3, 4, 5, 6 speaks upon with this. And how is this state government is classified? Friends, when it comes to section 4 of the enactment, the state is divided into division. This division is being divided into district, and that district is consisting of several talukas, and these talukas are comprising with circles and villages. This is how the classification, the boundaries are marked in respect of the state. And for all these things, for all this division, district, talukas are also included with circles and villages. All these things are being controlled by the state government. So, the state government shall have a power, or it is a competent authority to form any village, taluka or district, or alter any of them or abolish any such divisions that is been formed by them. But, however, the state government, when exercising this, it shall be subject to those conditions imposed in, but as by virtue of our constitution, we have to follow with the, or of course, not only by the constitution, even on the basis of just and equitable principles also we say this. That is, they are required to follow certain manner. That is, when the alteration goes with, alteration is being made with, they do also exercise certain limitation. That is, the limitation is that they first have to notify in the official gazette, hear the objections, whatever that is been coming across with, only after hearing that of the parties, that is the objections, then they can go decide for forming, altering, or even abolishing of certain divisions. Not only with the divisions, my friends, not only with the district, even with respect to the villages. They may have certain limit to the boundary of villages. They may also amalgamate 2 or more villages into one, and all this can be made only by the notifying in the official gazette, and also hearing the objections on such proposals, they can go for this division of all these things. So the state government shall notify and appoint that each division which is to be made upon with. All this is dealt under section 3, 4, 5, 6. These are the powers which the state government would exercise upon with. And apart of this, my friends, as I was saying, that each state is being divided, that is, it is categorized into division, into district, into each district can also be a assistant commissioner. So each district can be given with this, talukas, circles and oblasts. All these are there which can be categorized. And for each division, there can be an appointment of one divisional commissioner. When it comes to the divisional commissioner, my friends, this divisional commissioner is the chief revenue officer of that division or of each division, and he shall exercise all such power and the power of superintendence and control of those divisions as that of the officers subordinate to him, that of the officers who are subordinate to him, and he shall also exercise all those powers conferred upon him by the state government has the duties which is required to be carried out with. So in this way, my friends, we shall see that the divisional commissioner is set to work upon with. That is, he is the highest in authority. That is, after the state government can form a division, and this divisional commissioner shall do exercise all those functions. But the majorly thing that what we say is this divisional commissioner is the superintendent's authority, exercise the superintendent's authority with respect to all those of the functioning that is being carried through that of the revenue department. In fact, I can say you or put you in this way, my friends, I can state in this way that this divisional commissioner is a person who exercises superintendence of all those 4 categories what I was just mentioning to you in respect to the revenue administration is concerned. He would look to take care of all those things what has been specified there. Then comes the deputy commissioner. Deputy commissioner, I can say in this way, is the only officer who would be exercising the powers of both the state and central laws, or he would be exercising in terms of both the state and central laws, my friends. He is being given with certain power. If the state government restricts upon only to the exercise of certain powers, fine. Suppose say a commissioner of election, deputy commissioner of election. No way it is concerned with the land revenue, but he is given with the right to have even to exercise such powers under the central government. So in general, if you take, it is only this deputy commissioner is a person who can exercise such powers what is being granted to them both by state as well as central. Now forget about the election. If you take, say if a deputy commissioner has been appointed for the land revenue issues are concerned, that deputy commissioner shall also have a power to invoke the provisions of the Land Reforms Act or Karnataka, that is the Land Acquisition Act, which is a central enactment, and on that also he has a right to look in. So he can exercise all such function. That is the reason why I said to you that he is the only authority who exercises the functions of both the state as well as central. That is the laws concerning to the state and central. However, we see this deputy commissioner is subordinate to that of the divisional commissioner. So being a subordinate of the divisional commissioner, we shall say that whatever the orders, whatever the powers that is being entrusted upon him shall be exercised in accordance with the powers so granted to him by the or so that is assigned to him by the divisional commissioner or by that of the state government. And if you look upon with this, the deputy commissioner shall exercise all such function that is being granted to him as a chief controlling authority. That is, because he is being a chief controlling authority, he can discharge all those duties imposed under the enactment. That is consent enactment. He is to require to discharge all those things. So also in discharging these functions and duties, he can also confer upon or impose or delegate certain power to the assistant commissioner in the matter so specifically provided under the law, or where there is no matters, then if it is even the law does not speak in those matters, if it becomes necessary, then he can also discharge those functions what is being conferred or imposed even to that of the assistant commissioner, as that is provided under law. So that is the duty on the part of this deputy commissioner is that he shall carry upon with all those functions, perform all those duties in accordance with the instructions provided to him by the state government. So when he is acting in behalf of the state government and acting under the instances of the state government or at the instructions of the state government, the question arises is that is he an agent of the government? Can he be called as an agent of the government? Or can a deputy commissioner can be called as an agent of the government when he is functioning or when he is performing the functioning on behalf of the state? This was addressed in many number of cases, that is he an agent of the state? In Abdul Bashir versus state of Mysore, a very old case, when it was just Karnataka was a state of Mysore, I am speaking this, my friends. In this case, the court observed in saying this, it is wrong in principle to address the deputy commissioner as an agent of the government. Is only an officer who is being appointed under the revenue code and to discharge those functions what is being imposed to him under the statute. And why he cannot be called as the agent of the government is that because the code gives out certain discretionary powers to this deputy commissioner. So when the court is giving certain discretionary powers to the deputy commissioner, the deputy commissioner has a power of exercising those discretion which is not given under the authority of the state government. If you look at exactly with the agent is required to do only the act so specified or the powers which has been granted to him. But deputy commissioner is not that. A part of the instructions provided by the state government, he shall also have a right to exercise such powers which is discretionary in nature, which is vested in him, and he can exercise such powers. So in exercising of the duty, he would be exercising the statutory duty on one side, and the other side he would be also exercising certain discretionary powers which may not be specified under the code, which may not be expressly made under the code. So in that cases, in that senses or in that scenario, you can say that deputy commissioner is not an agent of the government. He would only be doing as under the instruction, he would be acting under the statutory duty, and also he would be carrying upon certain work as assigned to him by this government, and he cannot be called to be as an agent, nor is an agent of the government, we can say. So this is how the court expressed in respect of the position of the deputy commissioner, but he would be exercising all those functions there. And the deputy commissioner will have no implied power in the matter relating to that of land or land revenue administration is concerned. That is, the Land Revenue Amendment Act 1960 is said that this Deputy Commissioner is not competent to resume the land for grant of land. See, it says that is, when the Special Deputy Commissioner has given a grant or contravening with that of the land grant rules, if the Special Deputy Commissioner has given with certain powers to exercise this, then on the exercise of such power, he has no inherent power to cancel those grant and get back the land what is being made. That restriction is there. That is, there is an implied powers which is being there on that of the land administration in respect of the Deputy Commissioner, that there shall be no implied right on the part of this Deputy Commissioner to cancel away the grant what is being made by the Special Deputy Commissioner, especially in the terms of grants are concerned. He can exercise such power, he can do such functions, but he cannot override the powers of any other director or any other commissioners for that matter. So subject to this, my friends, we shall say he would be exercising this function. In one other case, that is in Professor A. Lakshmi Sagar was a state of Karnataka. In this case, I repeat this, Professor A. Lakshmi Sagar was a state of Karnataka. In this case, the question arose was that whether the impugned government order is valid. And the case was something like this. That is, under the direction as it was directed by the Special Deputy Commissioner, granting permission of the conversion of agricultural land into non-agricultural land was being made, and this was questioned by the Deputy Commissioner. And when it was questioned by the Deputy Commissioner and he refused to have this conversion, the appeal was being preferred, and on such appeal, the High Court quashed the order of the same. But when it was taken to a division bench, considering the scope of the powers of Deputy Commissioner under the Act, it said that Deputy Commissioner has power to refuse only when it is not in public interest. See, where a Special Deputy Commissioner who is being appointed for the purpose of expediting the issues of land concern, and if the Special Deputy Commissioner has passed certain orders, then though by nature he may fall subordinate, but by terms of position they are equal. By terms of position they are equal, I can say, but he may fall subordinate to that of the Deputy Commissioner. He may, but I don't say is exactly a subordinate, unlike AC for that, my friends. So when any orders is being passed there, then such orders cannot be withdrawn, or such orders of the Special Deputy Commissioner cannot be cancelled only or unless wherein that is in the public interest. So the Deputy Commissioner, if is to impose a stringent, that is, he has a power to impose a stringent condition as to the case may be, that is there. But in order to safeguard the interest of general public, if he is to do so, then the Deputy Commissioner shall have a power of exercising this. So in this, the appellate tribunal made it very clear that the government had no power in considering the request of the respondent in accordance with the permission of conversion. Of course, it was not against the public interest. So accordingly, the appellate tribunal said that no, the commissioner has a power in exercising such, that is questioning upon the powers that is being exercised by the Deputy Commissioner, that is by Special Deputy Commissioner. So in this way, my friends, all these functions would be made by this Deputy Commissioner. He can exercise all such functions what is being provided to him by that of the state. The third comes is the Special Deputy Commissioner, who is equivalent body, I can say. These two are equivalent body. That is, when the state government considers that for the purpose of expedite disposal or expedite work has to be carried in respect of the revenue issues are concerned, they can appoint a special deputy commissioner for any district. As I then said, deputy commissioner for each district, one deputy commissioner would be there. So for expediting, where if this one deputy commissioner is found to be insufficient, if is said to be overburdened with that of his work, and it may become inefficient for him to cater out to all the applications that is being made or to look into, then in such case the special deputy commissioner can be appointed in this regard. That's why we say that the state government by its notification can appoint such special deputy commissioner to such district. It is not to all district. Wherever the state government is satisfied that there is a necessity of a special deputy commissioner for the expedite of work to be carried out in such district, then under the notification, my friends, we shall see that such special deputy commissioner can be appointed. And if you look at the powers and duties of this special deputy commissioner, this special deputy commissioner shall exercise all such duties has exercised by the deputy commissioner himself. That is, what all the functions that a deputy commissioner would function upon with, or what are all the functions as is been specifically directed to carry upon the work by the state government, to such it is we shall see that this special deputy commissioner shall carry upon with. And mind this, as I then said, as both these two falls under the same category or same class, they are subordinate. Even this special deputy commissioner is subordinate to that of the divisional commissioner. And except where in the matter it is concerned, my friends, where the state government generally specifies the specific order on this behalf, it would be considered as the subordinate to that of the divisional commissioner. So special deputy commissioner who is been appointed has a special deputy commissioner shall be subordinate to the divisional commission, and he shall be in such district except to the matters, and he shall act upon except to the matter what is being provided. See, I was just mentioning you, I again want to clarify with this. See, generally we say that special deputy commissioner shall function all those duties of the deputy commissioner. But where this special deputy commissioner is appointed to carry out only certain kinds of work, then the duty on him is to only undertake those works what is being assigned to him, and not the other work for which he has been appointed with. So in such way he shall carry upon the work. The next comes is the assistant commissioner under section 10. Again, friends, this assistant commissioner shall be appointed for each district. And I can also say you like this. This assistant commissioner, in respect of the judicial issues are concerned, if I am to say, this assistant commissioner is the first appellate authority in respect of all those revenue matters. Is the first appellate authority. In some cases, the deputy commissioner can become an appellate authority. Of course, it is an appellate authority, but the first appellate, because of original jurisdiction, some of the cases it lies directly to the deputy commissioner. But otherwise than this also we say the assistant commissioner is the first appellate authority in respect of revenue matters. Otherwise than this, the state government by its notification appoint each district that as many as assistant commissioner it deems fit. It is, we say, again I repeat, the state government by its notification appoint each district as many as assistant commissioner as it deems fit. And this assistant commissioner would be subordinate to that of the deputy commissioner. So what we see is that, see, one division commissioner would be there for each division, and one deputy commissioner would be there for each district, where to expedite the special deputy commissioner can also be appointed by the state government. But when it comes to assistant commissioner, there could be one assistant commissioner or as many number of assistant commissioner as the state government is satisfied that is required to that of each district. So the state government may at any time give an in charge of this and say that assistant commissioner shall be in charge of all those revenue administration of one or other more talukas called to be as revenue subdivision. That is, he can be given, that is, each assistant commissioner can take several talukas into one and he can be assigned with those talukas to exercise how those functions in that of the talukas. And that's why we say that, that is, in respect of the revenue administration is concerned, he could be assigned with certain talukas where we call it as subdivision, and this assistant commissioner shall perform all those functions what is being conferred to him or given to or he has undertaken in other way under the act or for the state government which has given him a power for the time being in force. So in that function, that is, he would be carrying out, supervising out all those functions what is being given to him under a particular talukas. The assistant commissioner, when he is been appointed under subsection 1 of the act, we shall see that, and if he is being placed in charge of that any subdivision, then subject to that of the orders of the state. I repeat this, subject to the orders that of the state, my friends, he can also exercise the functions of the deputy commissioner. He can also exercise the functions of the deputy commissioner. That is, in absence of this deputy commissioner, if the state government is empowered upon with this, or if the powers are assigned upon with this assistant commissioner, then this assistant commissioner shall exercise those functions and perform those duties as the deputy commissioner has assigned to him to perform upon with. And what are those functions? See, when he is empowered with, perform all those duties in respect of the land acquisition too. That is, in the process of land acquisition, he can also, not only a revenue administration I'm speaking, if he is assigned to, if he is being empowered to carry upon the work as with respect to that of the land acquisition, duties are casted, if it is been casted upon him with respect of the land acquisition, then such can also be exercised by this assistant commissioner. A very beautiful case which has appealed to the Supreme Court, that is in state of Mysore versus Uchappa's case. The his lordship, an eminent judge of all the time what we have come across, is Justice Krishna Iyer. This Krishna Iyer has explained and observed with these notes saying that, bringing out exact legal position of this assistant commissioner under section 3 class C, said that the expression deputy commissioner as expressly included the assistant commissioner in charge of the subdivision. See how beautifully Justice Krishna Iyer speaks with. He says under sections 3 class C of land acquisition, while addressing upon with this, he speaks with this. The expression deputy commissioner has been expressly made to include the assistant commissioner in charge of the subdivision, but only such officer where is required to specifically appointed by the government to perform the functions of the deputy commissioner, then deputy commissioner alone can do. But when a subsidiary way or assignment of such an act is being made, then the powers cannot be questioned upon with. So they say that assistant commissioner in such cases where the government specifically has appointed for him for that purpose, then it said that the justice observed saying this, that the assistant commissioner does not require any such empowerment or authorization even by the deputy commissioner. So what we understand here is this, my friends. In the words of Justice Krishna Iyer, it says this, that is, the assistant commissioner can function upon all those work what is being assigned to him. But where if under the authority of this government, if is also required or if is assigned to carry upon the work of the deputy commissioner, then there need not be any such empowerment or there need not be any such authorization of having specially obtaining to exercise the functions of the deputy commissioner. So in a way I can say you this, my friends, that is, this assistant commissioner shall also have a power of exercising the powers of the deputy commissioner where it has been specifically provided with. I would also go with one more case here, that is in case of Balagopal Das versus State of UP. The same Supreme Court again explaining upon with this, it said that the state government is empowered to the assistant commissioner to appoint dharmadarshis of the concerned area, that is concerned religious institutions. They can appoint dharmadarshi except where the appointment of dharmadarshi to Huzarai is not allowed with. That is, Muzarai is not being allowed with. That is, to the Muzarai institutions are concerned, they cannot be allowed, but except of this institution, the assistant commissioner shall also have a power of looking into the appointment of dharmadarshis. So even to that extent, we shall see that the assistant commissioner shall exercise the power. So in a way we can say that the assistant commissioner of that subdivision is to perform with certain functions and duties, and if is going on leave, that is of a subdivision is been appointed, and if he is going on leave or if his place becomes vacant because of incapacity or because of his death, that the Tahsildar there can also be sanctioned with the headquarters, saying that is of the headquarters of the same of the assistant commissioner, unless provided under the Act, he can, that is this Tahsildar can succeed temporarily to the office of the assistant commissioner, and the work of what the assistant commissioner was to be required to be done if exercised by this Tahsildar, then it is deemed to be the act of assistant commissioner until such successor takes charge of the post of assistant commissioner. So in a way it goes a step further and says even a Tahsildar, while acting on behalf of this assistant commissioner, on his position or on his seat is vacant, then it is deemed to say that the Tahsildar have exercised the powers of the assistant commissioner. That's what it was taken in case of Patel Chennai Gowda versus Krishna Gowda's case. The question came up for the consideration that whether the Tahsildar working as an assistant commissioner by virtue of provisions 14 class 3 under Karnataka Land Reforms Act could exercise all such powers of the subdivisional registrar. There, the learned judge, hearing the arguments and making its observation on this, it said that the Tahsildar, he is deemed to be an assistant commissioner, though not he is a full-fledged assistant commissioner, and he could not exercise the powers of what an assistant commissioner is, but still the division bench of this said that as in certain cases he could be exercised and his actions can be considered to be the act of an assistant commissioner. So in this way, my friends, we shall see that the assistant commissioner shall exercise the powers and functions that is been provided. Later on, we see that Tahsildar are there. This Tahsildar is also one such authority, revenue officer under this, and for each taluka a Tahsildar is there, and he shall appoint one Tahsildar, that is state government can by its notification appoint each Tahsildar who shall be the chief officer entrusted with the land revenue administration of that taluka, and he shall be a subordinate to that of the assistant commissioner. This Tahsildar shall be subordinate to that of the assistant commissioner, and he can exercise all those functions what is being provided or assigned by the deputy commissioner or this assistant commissioner. So he can exercise all those functions, and when it comes to the duty of the Tahsildar, he can exercise those functions what is being delegated or where it has been expressly imposed to him by the Deputy Commissioner. That's why we see in case of Yamuna versus State of Karnataka, it was said that the orders of the Tahsildar while exercising the powers of the Deputy Commissioner, that is under section 94 class 3 of the Act, or by virtue of this delegation, he can exercise all such powers and function, and the powers and functions of this Tahsildar, as I was saying, is equated to the Assistant Commissioner or to that of the Deputy Commissioner. So you can even say this, that sometimes the Tahsildar shall have a power of having exercising the powers of the Deputy Commissioner or also the Assistant Commissioner. So that's what section 11 of the Act says, that though Tahsildar is subordinate to that of the Assistant Commissioner, but still even is given in charge of a taluka, then he has a right to pass an order in respect of that taluka, and he can seat himself in the position when assigned with. He can seat himself in the position of the Assistant Commissioner or Deputy Commissioner, and he can exercise the function, and the same can also be corrected when it is being done by the Tahsildar. The same can be corrected by that of the Assistant Commissioner. So in this way, Tahsildar is also being given with certain powers in respect of what it has been. So the state government by its notification can say these are all the powers, like including looking into the land records I am speaking. You can have a powers of all those areas. On the basis of that, the Tahsildar can exercise the powers granted, and also to exercise where it is been specified or delegated, he can do also exercise the powers of Assistant Commissioner, or where there is a specific delegation to exercise the power under the special order, he can also exercise the function of the Deputy Commissioner. So in this way, my friends, Tahsildar do also have a part of exercising the functionaries what is being provided to him by the state. See, the next comes is the special Tahsildar. Friends, when it comes to the special Tahsildar, maybe here and there we find with the sections that is being mentioned out there as 13.1, 13.2, we shall see this. Let us not just typically go with the sections there. See, the special Tahsildar is a person, whoever who has been appointed by the state government, considering him for the purpose of the said work that is to be carried of the Tahsildar is concerned. And here it says this special Tahsildar is a person who has been appointed by the state government for a specified period and under the notification as specified by the state government. This Tahsildar shall exercise all such powers, functions as what the Tahsildar is being assigned with. He shall also discharge all those duties that what is being exercised by the Tahsildar, and to, that is in respect of that taluka for what is being given to enforce. Because when I say Tahsildar would be given to in charge of each talukas. So out of each talukas, this special Tahsildar shall be assigned with certain work, and they shall function certain work as that is being assigned by him to the state government. See, we always say this special Tahsildar is subordinate to that of the Tahsildar, but it is not so. It is not so, because just it is becoming below this person. It is not that. Both these two also enjoy the same cadre of the position, but this special Tahsildar is subordinate to that of the Assistant Commissioner and the Deputy Commissioner. And the special Tahsildar shall, as I then said, shall exercise all those functions which is being provided to the Tahsildar, except where the state government by its specific order to this effect or to this behalf, if he has been assigned to work with a particular area for the, only with the particular aspect as concerned, then the special Tahsildar shall exercise such powers and functions as that is being provided. So this special Tahsildar is a person who is being deputed to work and is being given with certain subordinate rights and duties as that is order passed by the divisional commissioner or by the deputy commissioner, and he shall be liable to that how the work what is being done. But when the same, when he is being employed with, he shall be liable, that is his orders or his act is subject to the revision and confirmation of the Tahsildar or the special Tahsildar, whatever it is subject to the revision as consent. So this is how the special that is. Again, I can say for the expedient of work to be done for each talukas, the special Tahsildar can be appointed with. Next comes is the revenue inspector. The deputy commissioner may, after the subject, that is by its general orders, may subject to such provision and its general orders of the divisional commission, appoint a revenue inspector for each circles or oblis. He can be appointed for each circle and oblis, and this revenue inspector shall perform all those duties of which the revenue inspector is provided or prescribed under the Act. He shall hold the office and he shall also be governed by such rules that is laid down under the Act. That is, he shall function out all those like maybe for the purpose of examining the marks, or maybe purpose of examining the records, or for the purpose of taking out the taxes or collection of revenues. In all this purpose and all these areas, the revenue inspector would be working upon with. And then comes the village accountant for each village or groups of village, my friends. The deputy commissioner or the state government by its order, and the divisional commissioner also has this power, may appoint any person as a village accountant for each village or for the group of villages is concerned to perform all those duties that is being provided under the Act. In fact, the appointment of village accountant is when effective, when so made by the state government. When his appointment becomes effective. See, as soon as we say the word appointment, my friends, appointment is something, a name given to the person, the position given to the person, or a designation is being made to the person. That is a particular post. And the orders would become complete, or this process of appointment would become complete only when such person is given with the powers to enter upon such duties what is being provided thereof. That is, when he is being given a right to perform upon such duties, and when he has accepted to do upon such duties, functions upon such duties, what has been casted upon him, only then we shall say the person is said to have been appointed. That's what in case of K.S. Ramaya versus Tahsildar, which is reported in Karnataka Law Journal, my friends. The division bench agreeing to the duties thereof, it said that as a single bench decision, it said that, held that the deputy commissioner issuing an order of appointment of any person has a village accountant and posting him in a particular village is sufficient to say that the village accountant is continuing in his office. And it said that is, if the same deputy commissioner terminates the village accountant from the service of the village accountant who has been continuing the office, then it is not necessary that the appointment should be accepted and appointment should be jointly, his appointment should be made and he should join to the duty. It is not required that. So what we understand here is that, my friends, posting of a person to a particular village has also given a power to terminate the person from that of the post, and it further held that it is not necessary that the appointee should accept the appointment or joining of duty is not required there. It is not necessarily required. So we see that one hand, though we say that the appointee is required to act, but mere exercising of functions and duties in respect of the same is good enough that he has been appointed and he shall exercise all those functions what is being assigned. So such persons who is being appointed as a village accountant shall carry upon all those work, and that's what section 17 says, that the state government has prescribed shall also may appoint a registrar in this regard, and that registrar can also function upon, look into, that is this. So before I get into this register, sorry, I just deviated myself in this regard, just going down to the register. Let me first speak out to you with the accountant. And the duty of the accountant is that the state government is prescribed with, so that he shall have a part of entering into all those registries, look into the accounts, look into the records, and it should be kept in that of the village. And in fact, we can say, my friends, this village accountant is the supervisory head, or we can also say that he is the superior revenue officer to the concern of that village. And when we say that, that is this Tahsildar, he is a supervisory head of the taluka, shall also have a look into those of the works that what is being done by the village accountant. That is, he could look into the affairs of the village, and as required by the state and central government, my friends, he can give notice reports, and he can also have a master to be done by this village accountant. So this is one way what the village accountant can do, perform his function. Then comes the survey officer. Friends, for the purpose of this survey assessment, we can see that the settlement of land revenue, and for the purpose of survey or settlement of boundaries, etc., these surveyors are connected with, or it is they are being appointed with. That is, in these matters, I repeat again, for the settlement of land revenue, for the purpose of conducting the survey, or for the purpose of settlement of boundaries, for these issues are concerned, survey officers are going to be appointed under the Act. That is, the said government, by its notification, appoint such officers as it deems fit. And there we can see such officers can be appointed and designated as a survey officers. 1. The Deputy Commissioner of Land Records, Deputy Commissioner of Settlements is where we can call that as Director of Surveyors of Land Records. These two are considered as the Director of Land Records. Then for the purpose of Superintendents of Land Records, we shall see that that is for the Superintendents for Settlement of Land Records, land, or Assistant Superintendent of the Settlement, Land Settlement, under which we shall see that Assistant Superintendent of Land Records are there, Settlement Officers are there, and Assistant Settlement Officers are also there. And these persons would look into the act as they would be acting as a survey officers. I repeat this once again, my friends, to give you more clarity on this. See, when it comes to the survey officers, for the purpose, as I said, survey of land records or purpose of survey or settlement of boundaries for this. And there are 3 categories of persons who could be made. One is the Director of Survey Settlement of Land Records, Superintendents of Land Records, and of course the third one is duties of the Deputy Director in respect of Survey of Land Records. These are the 3 persons. When I say Director of Survey Settlement, there can be a Deputy Commissioner of Land Records, which is categorized, divided into, and we shall also see Deputy Commissioner of Settlements is there. When it comes to the Superintendents of Land Records, we shall see that Superintendents for Settlement is there. Assistant Superintendent for Settlement can also be appointed. Under this, we can see Assistant Superintendent for Land Records, Settlement Officer, and Assistant Settlement Officers are the officers who are being appointed under this. And when it comes to the duties of the Deputy Directors, that is, Deputy Director is in fact, we call it as a person who is a class 1 of the junior scale division. He is an officer who has been appointed under class 1 of the junior scale, and the jurisdiction is to the extent of 1 or other more district, that for the purpose of conducting both statutory and administrative powers, or exercising both statutory and administrative powers. What are the statutory powers here that he would exercise? See, the powers which enable him to undertake the reviews, that is under section 56 of the Act, to approve Kammi Jasti Patikas, which is an order, something like or under orders of correction of clerical errors. It is a Kammi Jasti Patikas means something which is the revenue is assessed less or revenue is more. To look upon with this, survey officers are being appointed, and to correction of clerical errors. For these purpose, my friends, the directors, deputy directors, or the officers given to him shall be exercising the power as a statutory powers. And when it comes to the administrative powers, this can again be classified into several ways or under several heads. It could be with the records of right. It is with the supervision of training classes. or for preservation of survey records, or it could be controlling and supervising of the work of the assistant directors of land records. In all these areas, my friends, we shall see that the deputy director will be functioning. So that is the reason why we said this, that this director would be functioning both as on the statutory powers and administrative powers that are being conferred. In fact, all these are the officers which are being considered of revenue records. And what is the duty of this surveyor? See, when it comes to the duty of the surveyor or surveying officer, we shall see this, my friends. There is class 1 and class 2 surveyors. When it comes to that is division is being made in the survey office itself. And what is class 1 survey officer? And of course, both these two is for the purpose of determining the boundaries done under the provisions of the Act. And both are these two given with the statutory importance to perform their duties and functions, which is of utmost care. They have to take utmost care in performing these duties. But what is this class 1 and class 2 do is each are been assigned with different forms of work. Class 1 surveyor is required to mainly attend the original items. The original items like the credentials of the survey or unsurveyed village, and it could be with respect to the city works are concerned, or it could also they are required to maintain and consider the works of the assistant directors of land records. This is the duty of them. Again, I repeat, they are looking into the credentials of survey or unsurveyed villages, the cities survey work, or they are also required to maintain the works considered by the assistant directors of land records. This is the duty of the class 1 surveyor. And the another duty that we also see here is that they are required to have a verification in the land acquisition, that is especially with the interstate boundaries that could also be made to them. This is what they work upon with. The second division of the surveyors is the surveyors are normally would attend the routine item, or they will be normally working out with a routine item like maintenance work, or where by virtue of their experience and aptitude, they would be given to function with how the survey is to be made, how it is to be taken care of, how the land boundaries are going to be marked. All this would be given under this, my friends. Under section 18A, we see that appointment of licensed surveyors is also provided. The state government, that is the director of the survey settlement of land records, may for the purpose of this provision, that is under provision section 128 and also under section 13 class C, we see that, and with the approval of the state government, subject to such condition what is imposed to them, that is licensed persons, they can grant even a license to such person referred to be as a licensed surveyor, where in turn this licensed surveyor can also be a person who could be appointed for carrying out the survey activities. And they possess, in fact, when they give a license to them, they should possess with certain qualification, the experience in this area, and only such persons would be given as a licensed surveyor. And when the survey is being made by this person, they have to you are required to pay a fee for them for that of the surveying what they have been done. So in this way, my friends, we shall see that the survey officer is also been appointed under the supervision of the state government. And finally, my friends, under section 19 we see the other officers can be appointed. The state government may appoint any such other officers to entrust such powers and officers in order to help out all these persons in respect of the same. So these are all the functions which we see that how the officers are going to discharge their duties as specified under the state